It has been challenged in the Honorable Supreme Court. It was placed in the 9th schedule. It was placed in the 9th schedule. And that has also been challenged.
In case of Maharashtra, it was challenged, my lord. There the assembly passed, it was made an act. Still it was set aside by the Supreme Court. That's
Sir,
part of the judgment that
in
we have filed.
the judgment
It's a
compilation.
part of my friend will.
Yes, my lord.
I
It's
think
not.
Tamil Nadu, I think they have exceeded that.
Yes, my lord.
They put it on the 9th schedule to
Yes,
avoid this challenge.
I'm just saying that, my lord.
That
31.
Kesavananda Bharati will not come.
Article
No,
31,
no.
they
I'm
take
glad my lords are asking
take
that
shelter
question.
under that.
My lords, in a recent decision of the Honorable
That
Supreme,
Kesavananda Bharati will not come even if it is included in 9th schedule.
may I answer that?
Expressive, my lord, the initial, they'll have an initial shield. If they put it
But
in the
nobody
9th
has
schedule.
challenged it.
No.
Increase it.
May I answer that, my lord? May I answer that?
Yes.
My lord, what the Honorable Supreme Court has said is, even though a law may be placed in the 9th schedule, if it violates the basic structure of the
That is
Constitution,
Kesavananda Bharati.
then
That's
also,
what we are asking.
then also it can be challenged. On that ground.
That's what we are asking.
Yes, my lord.
Has anybody challenged? Is the
They have
question.
challenged that 67% reservation insofar as Tamil Nadu is
What
concerned.
happened to that?
By an interim order,
Huh?
by an interim order, the Honorable Supreme Court is seized of the matter, but the reservation is continuing, but the SLP is yet to be decided. Here, well, my lords, interestingly,
Advocate General,
not
if you
placed in the
wanted to-
9th schedule.
If you wanted to make it, you should have included it in 9th schedule. No?
Not for, forget about 9th schedule, my lords. 9th schedule will be if it receives the imprimatur of the governor and it becomes law. Please see, it is still a bill.
Yes.
And they're very clever.
Yes,
Please.
yes, we have understood.
Yes, my lord.
It's a repetition, Mayor. We have understood.
I'm so sorry.
So far, it has not been enacted.
Yes, but
These are
please
one
see
of the contentions.
Yes, my lord.
Next.
And they're referring to a bill and not saying what the bill is for. Please see, the government have accepted
So when
recommendation.
it went to governor, date, when it went to governor,
I believe a month ago, my lord.
can anybody be specific?
The date.
31/8?
I just point out.
2025?
Yes, 2025. The bill is 2025.
It was introduced in the assembly on 31/8/2025.
31/8/2025.
The present just concluded
Panchayat Raj.
our monsoon.
Legislative Council is next day, 1st September.
And just read, my lord. The government have accepted the recommendation for reservation of backward classes at least 45% in rural, urban, local bodies in the state. Accordingly, the Telangana backward classes of seats in rural, urban, local bodies bill of 25 was passed in both houses unanimously by all the parties. So it speaks of about a bill which has not become law. In spite of the, Malad, I would even go to the extent of arguing an alternate submission. Even if it became law, we would challenge that law. But because it is violative of the law laid down by the Honorable Supreme Court, it would still be in violation of the law. And that is exactly what a bench in 2018 of this Honorable Court has said, to an increase to 34% for backward classes. They refer to Krishnamurthy and have held you can't increase it beyond 50%. That is at page 202 of your Lordship's papers. Please see page 202 for a moment. Manoj, please see 202. The fund, may I read, Manoj? Yes. Sorry.
201 it starts.
Yes. So,
Right, 202, right.
one thing, my lords, 285 cap A has been brought in on.
That's only an interlocutory order.
It is carried to the Honorable Supreme Court by the state and withdrawn. But the operative portion of law is important.
How
Malad.
can you rely on interlocutory order?
No, but what I'm saying is, it stopped the state on the ground of not
It
in
will not have
accord-
any precedent value.
Yes, but my lords, it's a division bench order. We are at the stage of admission.
It's also division bench.
Yes, yes. Concurrent holdings.
Huh?
Please see, para 10. Government having considered enhancement of reservation of backward class, because it says,
Para
man,
10 of what?
I'm only saying, government, of page
Para 10
30,
of what?
para 10 of page 30 of the GO.
You.
Yes. May I also read the judgment, my lord, since your lordships are seeing it, because you said it's
Right.
not bad. But just I want to show one thing to your lordship. Please see page 203 for a moment.
Yes.
Yes. Please see page 303.
Yes.
However, we are of the view. Now, this is before 285 cap A comes into the picture.
Correct.
The amendment was, this order came about in 9th July 2018, 9th July 2018, and the amendment was brought in with 285 cap A on 15/12/2018. So at the time when this order was given, 285 cap A was not there on the statute book. In spite of that, applying this Honorable Supreme Court decision, please notice, we are of the view that the law laid down by the apex court is clear and categorical to the effect that the upper ceiling of 50% vertical reservation in favor of SCs, STs, OBCs should not be breached in the context of local self-government. Exception can be made only to safeguard the interests of STs, scheduled tribes, in the matter of their representation in panchayats located in the scheduled areas. This is applying Rakesh Kumar of the Honorable Supreme Court. Well, only exception is STs. This is one of the specific enumerated conclusions rendered by the Constitution bench after stating to the said effect in paragraph 64 at page 227 of the judgment in K. Krishnamurthy, wherein the apex court had clearly taken the view that there cannot be any vertical reservation in excess of what has been noted above. It has also to be noted that K. Krishnamurthy was decided making specific reference to the Constitution 73rd Amendment and the 74th and the statement of objects and reasons of those amending acts. Considering the submissions of the learned special GP on basis of OBC population in the state of AP, this was also...
One minute.
Governor should not ask for reserve consideration to such. This is pending. Pending that actually क्या है? This is a general act. This bill becomes an general bill. Bill becomes an act. It has to be incorporated as a policy decision. Reported to all of these the application. Anything else is according to conducted empirical data and this population 53%. So reservation is interest of 40% is this is done presented by the government. Presented by the government. If no action can be the question of we are implementing it even this is what is history of the advocating of the constitution. This article only states that is. Then we can go into the subject. Correct. So, otherwise,
Yes, Advocate General. How do you overcome this section 200 of
Article 200.
Constitution, Article 200? Yes, Advocate General.
200.
Yes.
This your argument is this Telangana backward class reservation so and so bill 2025 has been sent for assent of the governor or that
Not the backward classes, madam. The backward classes has recommended that it be increased.
no
By
this
what
bill
was-
is
Yes,
pending
yes,
consideration of the
yes.
governor.
Yes.
Yes.
And
What is the process involved now?
the governor should assent. I'm glad your lordships are agreeing. to
Maybe
200.
Advocate
Yes,
General.
madam.
Mr.
Assent is mandatory.
No,
Yes, Advocate General. What do you
Mr.
say about
Unless
Article?
the
One
learned
minute, sir.
advocate- Yes,
He's asking you, just wait.
How do you get up this Article 200, sir?
My lord, the assent, your lordship will please to see that was the very same assent of bills was an issue before the Supreme Court, my lord. Justice Pardiwala said, my lord, in the event, Justice Pardiwala said, in the event that it is held for more than 1 month in certain cases, 3 months in certain cases, it should be deemed that the assent is given. My lord, in this case, assent is given, my lord, insofar as reservations are concerned, at 42% by the.
But you have said so, you should have said so in the GO itself, no? Then we have sent it, we have waited for 1 month. Said in view of the latest law laid down by the Honorable Supreme Court, it is deemed assent. or
1 month
something.
also was not
My
passed.
lord, as far as I know, it is.
This is a
3 months.
precise question we are asking in your support. What is?
Please wait.
1 minute, 1 minute.
My lord, my lord, not mentioning in the GO, my lord, I humbly submit to your lordship that not mentioning in the GO itself, my lord, does not make the GO any infirm, my lord, that's the.
Maybe right, maybe right.
My lord,
Whether that 1 month time is over or not, that is also not over, no, sir. That's all difficult.
Even 1 month is not.
More than 1 month is over, my lord, we'll make our submission, that's
No,
my
no.
primary
1
submission.
minute. 1 minute. We are not saying anything. In order to understand the case, we are putting some questions. That doesn't mean that we are against you or for them, or they can't say that we are against them or for, not like that.
Right.
In order to,
We'll, my lord.
Lord, in our writ petition, page 84, there's a bill.
Primarily, my lord, we make a request, my lords, for your lordships to have it immediately after vacation. They cannot
For
be the urgency.
for AG's convenience, at page 84, we have put the bill, my lord, in the second writ petition.
Is anyone having the copy of the bill?
Yes, my lord, page 84 in the second writ petition. AG can also refer it, learned AG. For your reference, just for a reference of all of us. Page 84,
Yes,
exhibit P6.
It's 3 months, my lord, not 1 month. I've read the judgment, it's 3 months. I don't have
That
it
is,
right now,
that
but
is
it's 3
31st
months.
August 2025, this is in assembly. And thereafter, I'm told legislative assembly, it has taken next day.
yes, this is for local bodies, sir. They have
Both are.
sent it, where is the question of?
It is.
Panchayat is at page 90. Panchayat is page 90, we have not filed local bodies. Municipalities, then Panchayat is at page 90, my lord. Same date, 31/8/2025.
Mayur, let us say,
So 19,
oh,
It's absurd, my lord, to say that 1 month and then say this is the law. Can it be said like that? And one more thing, my lord, this is what I'm trying to submit to your lordship. The honorable division bench of this court, while holding 34% is not to be allowed, apply the honorable constitution bench.
Yes, argue on this page 94.
Yes,
Yes, let the learned advocate general answer. Yes, Mr. Sudarshan Reddy. Mr. Sudarshan Reddy. This, see the bill, page, you have presented this bill.
Right, there's
Yes,
two bills.
to
One,
amend section 285A of the Panchayat Raj Act.
my lord, one bill is
Yes,
to
sir.
amend.
Governor's assent is pending consideration of governor's approval. Where is the question of going ahead with this? Sir?
My lord,
How can
may
you go ahead?
my submission before the lordships could be, if it is refused by the government, it stands
No,
on
no,
a,
wait.
it stands on a
Where did you
different.
say that? Where did you say that in the GO now? Where is the, see, this is, as a policy decision, you have conducted empirical, you have collected empirical data. BC Commission, dedicated commission has conducted inquiry.
Yes,
Population, according to your data, is 53 point so and so. You have decided to enhance reservation to 42%.
yes.
Yes, you passed a general, you wanted to pass a general law. Bill is presented, unanimously approved by both the houses, pending governor's assent. Where is the question of going ahead with this? How can you issue this GO now?
My lord, in
No,
circumstances.
it has not even become a law now.
In circumstances of this nature, my lord, if the governor refuses, my lord, it stands on
No,
a
no,
different. My lord,
this
I'll bring
bill
to you.
itself is for amendment of what, this section 285,
That's the reason, my lord.
for increasing the cap.
In the event, my lord, the governor were to refuse it, it stands on a different footing. When it is pending with the governor, my lord, I would make my submissions before your lordship.
Show me,
On the or any your lordship has. my
please
lord,
show us any judgment which says pending assent of the governor, you can go ahead
this
with
is a house
implementation.
motion. This is a house motion which is moved before your lordship.
This
Me
is
to
only,
argue, my lord, as if it is a final hearing would be a difficulty, my lord.
Mr.
I'm-
Sudarshan Reddy,
You stand that.
there was some constitutional restriction because of law laid down by Supreme Court.
No, my lord, even the Supreme,
Restricting
my lord, even the Supreme Court.
Reservation, please, 1 minute. Because of law laid down by Supreme Court in Indra Sahni's case and subsequent judgments,
Direction.
sealing reservation to the extent of 50%. Now you have decided to amend section 285A of the Panchayat Raj Act 2018. Yes, you have presented the bill. You have sent it for the assent of governor. Governor has not given assent. So where is the question of going ahead just because High Court has, and you say here, Honorable High Court of Telangana, its common judgment dated 25/6/2025, WP number 2661 of 2024 and connected cases, has directed state government to complete. For the sake of complying with this order, you will now go in a post-haste
Your Honor,
manner.
that I wish to
And
add,
see, pending assent of the government, can you go ahead?
wish to add something. The
things,
direction is to complete the election process, not this process of
1 minute.
reservations.
No, 1 minute. You
No,
can
without
have-
the
1 minute,
Supreme-
1 minute. You have two alternatives, Advocate General. You must at least go and file extension petition in that writ petition number 2661 of 2020.
No, that's what I'm clarifying. For a moment before he answers, I just need to clarify.
Filing it
One
on the.
aspect, Advocate General, just a minute. The bench never said that await the reservations. The Supreme Court said that if the reservation, this thing can't be done, you proceed with the existing list. That is settled law. That is settled law. So therefore, the bench never gave this time to enable them to complete all that exercise. Irrespective of that, they must hold elections.
No, they can seek extension.
Today, they
of-
can't
no, no,
take shelter
one-
from
one
that.
minute. They can file an application seeking extension of time.
That they could have taken,
No, no,
notwithstanding
1
that.
minute. What is the stage of that before the governor? Anybody can throw some light on
That we
that?
probably we
I
cannot.
believe he has sent it to the Honorable President, my lord, for clarification.
What is the stage?
Because it's with the
with-
President.
What is the stage before?
We can't be saying that.
Huh?
My lord,
No, probably none of us.
No, no, Mr. Vidyasagar, you please inform this court pending assent of the governor when they have passed a bill. Governor's assent is pending. Where is the question of can they issue this GO? Please inform.
Does it become a law?
No, no, you as an officer of the court, you please guide the court. You
Independent of the.
1 minute, yes.
constitutional mandate.
Can they do this?
There is no reasoning given in the GO.
Forget, please answer our question. Can they do it or not? Our prima facie opinion is they cannot do it. Please tell us.
Unless the president assent is, or governor assent is
Yes,
deemed.
they cannot do it.
There is one aspect. Suppose if you want to really increase to 42%, then file an extension application in that writ petition that is 2661 of 2024 seeking some 3 months time. So that pending assent of the government, postpone these things. So we'll not comment anything on this. You file an application in the 2661 of 2024 saying that you can seek another 3 months time in view of the latest judgment of Supreme Court, whether it has become final or not final. Because again, presidential queries are there before the before the Supreme Court, whether
Matter is
Supreme Court can give a directions to the governor and all those things. That's an issue. Now, as on today, 3 months time is prescribed in your one particular judgment. If it is not given any assent, then it is deemed to be law, right? So you file an application seeking extension of time by 2 months, events are not going to fall. Your decision to increase to 42% also will be sacrosanct. The way you want to do it, you can do it. But it is not even 1 month pending before the governor, no. That's the point.
Wait.
my lord, the whole submission before your lordships, my lord, if your lordships, pardon me, my lord, if your lordships would have it after vacation, our
No, then-
submission,
If
my
you-
submission before your lordship.
No, 1 minute. If you want to get instructions, we'll have it tomorrow.
Not tomorrow, my lord, your lordships may have it on the reopening day, my lord. It can't be, my lord, there can't be an urgency in a matter where, my lord, a welfare.
Please,
My lord,
we are not coming in your way in increasing the reservations in respect of BCs from 25 to 42. But do it in accordance with law, no. You go and
We'll bring it to your lordship's notice, my lord. We'll satisfy your lordships. My lord, a welfare legislation of the state, my lord, cannot be, my lord, by your lordship may pardon me, cannot be interfered.
That goes to the root, no, that goes to the root. Because without there being an enactment, how can you go in anticipation of something?
There are two things, my lord, which I would like to bring to your lordship. One, my lord, the amendment which was made, and my lord, the act which was made, the legislative competence of the state is there. My lord, when the legislative competence is
No
there,
doubt, sir, that's your bill is there, it is pending assent, it has not
Thank
been.
you, my lord. Your lordship may kindly, my lord, legislative competence of the state is not in question. My lord, the legislative competence is there and that legislation is passed unanimously.
Unless it is accepted by the governor, it will not become the law, no.
My lord, I'll bring that, your
How
lordship.
can you implement?
My lord, in circumstances of this nature, my lord, where there is a legislative competence with the state, my lord, which is clear and my lord, which is not in dispute that the legislative competence is there, my lord, a mayor,
Not like that, senior, try to understand.
mere assent of the president or the governor, my lord, is not an issue, my lord. It does not debar the state from making a law accordingly. My lord, a welfare legislation cannot be interfered with, my lord, by way of a house motion, my lord. Your lordship may pardon me, my lord. A welfare legislation cannot be interfered, my lord, by way of a house motion, my lord. Your lordship may hear it, and my lord, your lordship will take a decision on that. Nothing hampers, my lord, between
No,
today
no.
and.
One minute. Uh, If elections are not conducted before 30th September, events are not going to fall. You are conducting elections just because of an order passed in petition number 2661 of
We
2024.
are very different, my lord, from the honorable courts, my lord. We are very.
One minute, sir. There are so many instances, state has come and filed extension application to conduct elections.
Try to file it also, my lord.
Right, you can do that. So you can see, because 1 month time is almost over, as on maybe by 30th September, 1 month will be over. You can conduct elections in the month of November, after 3 months time, if whatever the law is laid down by the Honorable Supreme Court, right? So after 3 months, you can come up with an argument. We have waited patiently for 3 months, now that governor has not enacted, I mean, so it becomes a law. So if you conduct elections, here in the month of November, two objects will be achieving. One, you will be complying the law. This is subordinate legislation. The main legislature, that is 285 itself is not amended. There's a question of acting on this is a question now. Now, you'll be complying 42% also if you wait up to. Have patience. If you want to do something good for somebody, you must wait. You must follow the law. Then nobody can question you. That's the point. Now, what happens is, only for something, you say, yes, we are, no, 1 minute. Only to say, yes, we have given 42%, it is courts who have interfered. Don't say that, because if you want to really extend that 42%, follow the law. Just wait for 2 months, events are not going to fall. Conduct elections in the month of November or December. That's it. By which time you will be complying that 3 months period of latest Supreme Court judgment. And if the governor doesn't give any assent, also, it becomes a law. Then you can act upon.
My lords may kindly have it after petition, my lord. We would like to satisfy your lordships on that aspect also. My pleading before your lordships is not by way of a house motion, my lord. A law made by.
Suppose election notification is issued, then writ petitions cannot be entertained.
Even
That's
then.
the law of the land.
That's
Only
the
election
problem.
petition, that's
That's
all.
the
My lord, the arguments which are now sought to be put forward by the petitioner saying that it is a constitutional violation, your lordships can look it at any stage. My lord, it can't be.
Once election process starts, we are precluded.
Mr. Sudarshan Reddy, when parent legislation is pending assent of the governor, where is the question of subordinate legislation?
My lords may kindly allow
No,
me.
please answer this point actually if you want.
That's the very query I am answering, my lord. My lord, two things, my lord. How do you look at a legislation is my lord, it's in the constitutional framework. First, my lord, whether there is legislative competence for the state. My lord, the legislative competence.
You have given reference, please see page 30, you have given reference of pending bill.
That's
It
what,
is
my
the
lord.
bill, based on that bill, you are issuing the subordinate legislation.
I'm not, my lord, your lordship may give me an opportunity to make my submission at once.
No, you please give us assurance, either you defer the election process, if you do not want us to interfere, please give us assurance that you will defer, you
We
take we will not interfere, but
Not interfere.
You-
We will not interfere with your G9. Only thing is, if you want to get instructions, we'll have it tomorrow. Just come back.
Maybe tomorrow, my lord. Your lordship may have it on Monday, my lord.
No. By then they'll bring in the notification.
You have instructions?
yes, Mr. Sudarshan Reddy, anyhow, Dasara vacations are there. We don't
Yes.
think you will go ahead with the election. You give assurance that you will defer the election process for a period of 10 days. We will hear the matter after vacations. You
Lord,
defer the election process.
What?
But I cannot, my lord, I
You are
cannot
issuing
give
an
an
election notification? Are you issuing any election
The
notification?
moment the state government gives a concurrence, I have to issue the notification.
When
Deadline
they are
is
going,
30th.
when they are giving the concurrence?
But as an, when they give the concurrence.
No, can you wait for up to 6th?
But as per the mandate given by the constitution and the Panchayat Raj,
No, no.
I am required to conduct.
1 minute,
the
sir. Advocate General, you are not coming in your way of enhancing the reservation. Follow the law and do it. This kind of thing, suppose if we stay this or set aside this, then it becomes a problem. The purpose for which you have undertaken so much of exercise by appointing one-man commission and all those things, and the effort made by that one-man commission will all go in waste. You must also understand. So, you get instructions that you are not going to act till 6th, then let the regular bench hear the case, because your object appears to be very noble, depending upon the population, you want to increase and all those things. Maybe that is the policy of the state government. But it should be enacted first. Last 285A has to be amended. Then you can do whatever you want.
And the
My lord.
judgment rendered by.
1 minute, sir. What is
Mr.
it?
May I just say something on facts, ma'am? Something on facts, exist Advocate General, and also the election, my friend. Last-
My lord, I have not been asked. My
I'll just
question-
say something, then Advocate General can respond. Mr. Advocate General, just a minute. Lord, whenever we were requesting the election commission to go ahead with the election process, their stock answer was that unless the state government gives us a concurrence, we cannot do anything. So if they can defer the concurrence till for a week's time, nothing is going to happen.
Let the regular bench decide. As a council.
Because
you
election
did- 1
commission
minute,
awaits
1
the
minute,
concurrence
1
from the
minute,
state
1
government.
minute. As a council, you did not give any undertaking. You get instructions, if you want, we'll hear the case after 15 minutes or 10 minutes, so that you can get your instructions from your respective clients. Then take a
They
decision.
need to make arrangements and get concurrence.
My lord, before that, my lord, to the queries put by your lordship, my lord, I was
Government
not.
will have to make arrangements.
My lord, to the query put by your lordships regarding, my lord, the assent is necessary or not, my lord, your lordships have asked me a query, I did not even answer it, my lord, everybody is picking up in the middle. My lord, my contention before your lordship says, one, it is always legislative competence. My lord, legislative competence of the state is not in question by the petitioners or by anybody. The legislature unanimously, my lord, I did not complete, my lord.
What if the government returns?
Yes, yes, please proceed. Sorry for interfering.
But the legislative competence is not in question. The legislature unanimously passed resolution, my lord, to increase it to 42%, my lord, one. My lord, insofar as amendment of 285A, my lord, it is pending assent with the governor, one, true. My lord, when there is legislative competence, a mere pendency does not debar from the state to act in pursuance of its legislation is my contention before your lordships, which I would like to satisfy your lordship on the reopening day or any other day. My lord, it can't be, my lord, even in Krishnamurti, I'll just read one paragraph in Krishnamurti. My lord, Krishnamurti, we have appeared before this honorable court. I'll just read one paragraph of Krishnamurti, my lord. While 50%, I'll just read it for your lordships. While 50% shall be the rule, it is necessary not to put
Please see.
out of.
1 minute, sir. What is this kind of argument? We are hearing Advocate General, you are disturbing.
I'm absolutely at a loss.
Yes,
My
please,
lord,
please.
while 50% shall be the rule, it is necessary
Which
not to put out of consideration
Which
certain
paragraph?
extraordinary situations inherent in the great diversity of this country and the people. It might happen that in the fixing and remote areas of the population, inhibiting those areas on account of their being out of mainstream of national life and in view of the condition peculiar to and characteristical to them need to be treated it in a different way. Some relaxation of the strict rule may become imperative. My lord, these are various contentions which we could write through days before. There is no hard and fast rule. My lord, insofar as this state is concerned, it is this situation where empirical data is there was never considered by the Supreme Court
Yes.
at any point of time.
Mr. Sudarshan Reddy, you have decided to amend section 80.
If you want, you can get instructions from your state, whether it can differ up to 6 is a question. Then, and, uh, and also take a decision whether elections can be postponed. Only thing is you'll have to file an extension petition.
That's what I wanted to clarify, Lord. They need not even use the words postpone. Don't give concurrence till 7th. That's enough. Lord. Because today the steps are that the election commission will send them a letter. Then they will have to say that all arrangements are made and we are giving concurrence. And today, when this 42% is reserved, but they will also, actually speaking, they require some time. Which particular case, which particular seat will go to SC, which particular one will go to BC. It takes time. This is what they have been saying. When we have approached the Supreme Court, your lordships were part of it. And then the election commission said, we can't do anything unless the state government gives a concurrence.
Consent.
So today that consent and concurrence, it can be it can be postponed till 7th for a next 1 week period. That's enough, my lord.
Have it on any day, my
We are
lord.
not postponing the elections.
I can get my instructions.
Please get instructions, Advocate General. We are not coming in the way of your noble cause of enhancing from 25 to 42 or whatever you want to do. Do as per the law, that's it. It's a matter of only 2 months or maybe 1 month. For the present, since it is a house motion, you'll have to get instructions, don't do anything till 6th. Next.
Lordship, may I have it on any day, my lord? I'll get my instructions. And so far, my instructions are concerned. Apart from instructions, my contention before your lordship.
We have heard, you know, that's a route that goes to the root to Advocate General. Try to understand that.
My lords, even if the assent of the governor is not given, my contention before your lordships that in view of the legislation, we can go along with this.
No,
Apart
that
from
is,
that,
Your lordships may decide the matter on that aspect.
your lordships may want us to get
He
instructions.
wants,
Get instructions. Any day, your lordships.
We have difficulty in.
so you are forcing us to pass stay orders. What is
No,
it?
my lord, your lordships may have the instructions on any day and for the purpose of inspection.
No, right now you can get instructions. What is it?
Please get instructions within
5-10 minutes.
15 minutes, 5-10 minutes, because
No, I try to contact them, my lord.
yes, you give some undertaking that the election process
giving
will be deferred by 10 days, that's all.
I'm
So
not
that,
giving it undertaking, my lord. I'll call the, my lord, the secretariat and find out, my lord. I can't give
Yes,
any.
yes, please, find out and give
We
undertaking.
are not asking you to give any undertaking.
I'll find out.
Perhaps I am stretching myself and saying that even undertaking, they may only say the process will take some time. That is enough
1 minute.
for a week's time. That will take care of.
Yes, Senior Vidyasagar sir. Law is very clear on this subject. Until unless 285 is amended, they can't do anything. The Parent Act should be, then the question of subordinate legislation would arise. So, only thing is they'll have to file an extension application in the 2661 of whatever
For
case.
the next single judge. And what is there?
That's only,
Procedural.
that's the procedural.
Procedural. Because
So that-
under the act, unless they give a concurrence, I cannot be compelled to conduct the elections.
That's what I
And there
said.
is a necessity because
Act on, act itself
Don't
says.
hurry things so that you end up into legal issues, legal problems.
because elections were held in 2019, long back. 2 years is
So many years pending to.
So
10
many
years.
writ petitions we have argued before the learned single judge to expedite.
It's been pending
So
for
The
years.
expedition orders are in before a single judge.
Before the single.
His lordship also sitting single judge, municipalities matter came before your lordship. Panchayat matter came before the other
Both
bench.
municipalities and panchayats elections are due.
Simple petition for extension.
Yes, that's, any other advocates who want to add that, advocates who are supporting BC cause, that's a
Yes,
good cause.
may-
That's both
may-
true. Yes,
May I submit, my lord? I am Prabhakar Chittoor.
you can say so, some things, still Advocate General gets some instructions. Yes, you want to add anything?
Lordships, with
I only
great
want to
respect
add one thing before my friend reacts. Probably you would not have heard. It's not as if the quota as BCs is being challenged here. The challenge here is, if you take this, if you implement this, you exceed 50%. That's our problem. Not that the X community is given more or Y community is given
That's a
less.
different thing.
That's our
My
thing.
lord,
That's the problem today.
may I say one thing, my lord?
Yes.
If you're with your lordship's permission, may I say one thing, my lord? May I say, my lord?
Anyway, till Advocate General gets instructions, we can hear you.
My lord, there is no such a Lakshmana Rekha, my lord, that the 50% cap should not go beyond it.
Okay, that's not an issue here. What we have
Yes.
argued, the 285 amendment is pending before the governor. And
Yes,
before
yes,
consent
yes.
being granted, can the state government go ahead with this? Joe is the only question that goes to the.
It appears, my lord, that March 30th was the day when that was sent to the governor. March 30th, it appears, my lord, it's subject to the correction by the learned Advocate General. What we have learned is that was sent on 30th of March. So therefore, it is almost,
31st August, not March. 31st August. Next.
May I submit, lordships? The Learned Senior Council has been appeared before your lordship that they didn't challenge any rules.
ఈ లీగల్ పాయింట్ కి
statutes.
చెప్పండి సార్ 1 minute ఈ లీగల్ పాయింట్ కి చెప్పండి until unless 285 is amended it is pending for governor how can this line get
Allow me to 1 minute, lordships. Allow me
Yes.
to 1 minute, lordships. The Learned Senior Council appeared before your lordships by challenging the GO. Neither they challenged the rules or any statutes or any constitutional validity of acts, lordships. And under these circumstances, with great respect to this honorable court, with great concern to this honorable court, writ rules 14A sub rule 6 has categorically stating that, my lord, this matter would go to the learned single judge. With great respect to this honorable court, with great concern to this honorable court, I may be permitted to read it that 14A Roman
1 minute
6.
sir 1 minute sir we have not hearing this case on our own this is allotted by honorable chief justice as a master of roster so our hands are tied okay don't argue all those
But
things. Next.
rules are in force.
Okay, forget about all this. You can go and complain to the chief justice. Why he has posted
I'm
this?
very sorry, my lord, so that I said that with great respect to this honorable court, with great concern to this honorable
Mr. Prabhakar, 1 minute, 1 minute.
Oblige.
Advocate General point. Any other counsel? So many persons are online. Nobody is saying anything. Feel Advocate General because we are getting bored. You must say something, no? Yes, Ramesh.
Point out, if you see the amendment also,
Yes, we have seen
it
that.
is there. No, the proposed amendment also
94.
says that we will make it in tune with the demographic requirement. But then they can't get away with that Supreme Court judgment which said we above 50% cap.
You will see.
My-
this.
My lords, this is Ramesh
They
Chilam.
have mentioned this
Yes,
bill in
that
the
is
GO.
the
Where
first-
is the-
This is the first hurdle.
And proportionate reservation.
where
for
is the
BC
question of issuing this GO, awaiting the assent of the government?
This is the first hurdle. The next hurdle is
Let
that
them grant this hurdle first.
administrative has taken care of it. See that they don't get out, they can't get out the 50%. quota.
Yes, any counsel.
And what learned Advocate General was
My-
reading
My lords, this
was
is Ramesh
summarized in the
Chilam.
last para, not the same
Actually,
judgment.
My lords, actually,
Since
the
19,
state government, my lords, by way of
No, no,
the
that is, yes,
ordinance,
that was online, no? If they
July
want to add any
15th,
point,
2 World Cups have gone by.
1 minute, just 1 minute. Councils are appearing online. Still, Advocate General get some instructions if you want to add anything. This is a basic legal issue we have raised.
Yes.
Without amendment to
And-
285, anything, anybody wants to say anything, you are entitled to say.
On legal issue, Milord, which my learned senior counsels were referred judgment, Vikas Kishan Rao versus State of Maharashtra, 5 judges bench judgment, Lordships. Para 63, I may be permitted to read it, Lordships.
Read.
As noted earlier, social and economic backwardness does not necessarily coincide with political backwardness. In this respect, the state government are well advised to reconfigure their reservation policies, wherein the beneficiaries under Article 243D subclass 6 and 243T subclass 6 need not necessarily be contemporaneous with the social and economical backward classes for the purpose of Article 15.4 or even the backward classes that are underrepresented in the government jobs. For the purpose of Article 16.4, it would be safe to say that not to all of the groups which have been given reservation benefit in the domain of education and employment need reservation in the sphere of local self-government also. This is because the barriers to political participation are not of the same character as barriers that limits access to education and employment.
Prabhakar, you're not understanding why you're reading that. Try to understand. The state government, what it says is, it intends to amend 285 and it has submitted that bill before the governor. Governor has not given
He's reading
assent to
Krishnamurthy.
that particular bill. Until unless he gives assent, it will not become law. If it is not law, it can't be implemented. That's the only question. Please answer that. That's only, that goes to the root.
my,
Don't say all
my
those
lords,
things.
may I add, my lords, with lordship's permission, my lords?
Lordships, so
Actually,
one sentence I can complete,
can,
Lordships. Ramesh Okan.
oh, sure.
This calls for some fresh thinking and policy making with regard to reservation in local self-government. This is my humble submission, Miller. The government is having in this welfare legislation in the self-government having power to make the policy. This constitutional bench judgment at para 63 stated. That's my humble submission with great
So
respect.
beneficial legislation, it did not be sent to governor, huh? What is this kind of argument?
Lordships, the Honorable Supreme Court 5 judges bench, which has stated, I submitted before your Lordships.
Taken care of.
As long as 285 is staring at you, as long as 285 is not amended, you cannot come up with this. Supreme Court.
In fact,
If 285 is amended,
para
then
63
perhaps
favors the merits.
we can go into the merits of the case. We must clear the first hurdle itself, said, must clear the first hurdle.
But his
That's the reason we are not setting aside that you are anything. What all we are saying is, let the government file extension petition before single judge seeking extension of time for conducting Panchayat Raj elections and wait for the 3 months in view of the latest judgment of Supreme Court. If no assent is granted by the governor, it becomes a law, then you can do whatever you want. That's the point. Suppose if we stay this, set aside this, then it comes back to the square one. Again, this 1 minute petition. So much of exercise state government must have done. It all will go in waste. You must also support the petitioners. If you want this benefit, it should be in accordance with law. Because this exercise of GOMS number 9 is not in accordance with law. If you want to pour some life into 9, you must wait.
How can we support, Millard? For the past 75 years, we are not in the self-government in local bodies, at least 30 to 35% Lordships.
Mr. Prabhakar, we are not on merits. We are on
Legal issue.
legal issues. Legislative competence is an issue here.
My lords, may I submit, my lords? This is Ramesh Chilla.
Yes.
My lords, actually, the ordinance was sent to the governor, my lords, on 15th July, my lords.
Aina 3
I,
months కాలేదు కదండి.
yes, 15 more.
Yes.
As your lord. Yeah, but that was delayed without no sending back, so that no the state government took the route in the legislative formulas, and they introduced the bills in the assembly in the August 31st. Just I wanted to add that no,
Of course,
even
senior,
before.
if the state government give concurrence, you don't have any option to, you can take some time now, because finalizing which candidate should contest from where and all those things, you are the
But
person.
I require 45 days, the day on which they give concurrence for conducting election.
So nothing will happen in this 1 week. You are not going to issue any notification.
We will be issuing a notification from that day, 45 days is
Huh?
From the date of consent.
from the date of the consent, when the concurrence is given.
No, when you will be issuing notification, election notification?
The moment they give the concurrence, because I have made all the arrangements.
With that form.
We have
Maybe,
only-
maybe in a day or two.
Yes. Because only the reservation issue and identifying the constituencies will be the role of the state government. All other paraphernalia we have undertaken. In fact, we addressed the recently also letter in terms of the directions of the learned single judge that we are willing to proceed subject to concurrence.
Suppose if we say, don't touch the governor gives consent, and it will also helping them.
Time for
Learned AG has come.
Yes. AGS.
Yes, AG.
My lord, I am unable to get into contact with anybody. Your lordships may have it on Monday or Tuesday, my lord. Because tomorrow is Sunday, my lord. A little late in the evening, my lord, I am unable to contact it, my lord.
Then
Lordships
maintain
may-
status quo till Monday.
Yes.
They can't be, my lord, may I request one thing, my lord.
No, anyhow, Mr. Sudarshan Reddy, there are only 2 working days next week, all are general holidays.
Yes.
May I request one, I'm unable to, my lord, I'm not being made, my lord, allowed to make my submission. I'm appearing for the state, not for that petitioners who are there on a peevish issue of 42% and 58%. My lord, I'm not on that. My lord, elections cannot be conducted in 6 days, no matter election commission or the state. No elections can be conducted in 6 days, even if your lordships will have it on Monday also, or the 6th or Monday. Would an election be conducted in 6 days? My lord, notification, my lord, after a notification it is given, it's 45 days. 45 days time is given. My lord, you will have to identify each of the reservation points, whether it is reserved for lady, it is reserved for BC, it is reserved for SC. My lord, I'm surprised that a house motion is moved. 45 days is the notification time.
1 minute, we have understood. 1 minute. 1 minute. Election notification is not a challenge, but it's already moratorium there, what it can be heard. Maybe, senior, it's like this. Once election notification is filed, you cannot challenge. But these writ petitions are filed before notification.
yes.
So nothing will happen. So we'll have it on 6th, right?
My lord,
Yes, but-
Cases, once notification
Till
is
then
filed,
status-
1 minute, sir, what is my, not able to understand. Once notification is filed, you cannot challenge notifications and elections. Now, this writ petition is filed before notification, so we'll hear on 6th, as rightly Advocate General said, elections cannot be completed within 6 days. We'll hear this on the reopening day before a regular bench, right? Post on 6th.
Obliged, I'm deeply obliged.
Now that this has fallen from the honorable court, Lord, would it be made a part of the, because what happens is any steps taken by them. Otherwise, Lord, this rule of list pendants.
1 minute, sir, 1 minute.
Lord, Lord, your lordships have put up, Lord, just as my Advocate General has made a very comments, scathing comment on us that the peevish writ petitioners.
No.
But they may be peevish, but we then we also require.
If the,
Lord, it's
if the
a-
notification
One
comes
second.
tomorrow,
We'll respond.
Mayur,
We'll
You
respond.
have not
But
understood.
what we are
Senior
saying,
counsel-
your lordships are
senior
absolutely
counsel
right.
Understood. 1 minute. Mayur, even if notification is there can't be challenge to that notification. These are all writ petitions filed before notification. They have to be heard and dealt.
Well, let it be observed by this honorable tribunal.
Huh?
Let this be an observation. Because what happens is the doctrine of dispendence may not apply in
Right.
case of an election notification.
Correct,
Your lordships may make it as a part of a court order
correct.
that nothing is going to happen.
Notice before admission. post on reopening day 6th or 8th? 8th October 2025. And it is made clear, even if the election notification is issued for conduct of local body elections, the cause in the present writ petition survives and it has to be heard on merits.
Then status quo, madam.
What is? Pass such an order like this. All right, done.
As if
Obliged. That takes care, man. You don't get worried.
We have decided to hear you.
Yes.
Please proceed.
And my subsequent to your lordship's question that whether it's gazetted or not, I've been instructed it's gazetted.
Very well.
Well, the present GO, my lords, has been challenged on the ground, my lords, that it seeks to increase reservations, vertical reservations, my lords, of BCs, which was hitherto 25%, my lords, to 42%, while maintaining the reservations of SCs and STs, my lords, at 15 and 10%. My lords, our contention, whether it is single or several, my lords, is only only one contention. The contention,
SCs were?
I'm sorry, my lords,
SCs?
SCs were 15,
There's no change in this.
there's no change in that. And STs are 10.
There
Well,
is a change.
yeah.
Earlier it was 6 or 7. Earlier it was 6.
Yes, yes, it has been slightly tweaked, my lords, wherein for STs, yes, my lords, I'm obliged. It was earlier lesser, they increased it and they reduced it for BCs to 25%, which it was earlier.
No.
Earlier it was 27% for BCs. Now, prior to the present GO, my lords, it was 25% BCs, 15% SCs, and 10% STs. And as your lordships have correctly, my lords, corrected me, there's been a slight tweaking earlier, when it was earlier 27% BCs. And then,
No,
my lords,
this
they,
25% is there since ages.
yes, that's, yes, obliged.
From so many decades, it is 25%.
Yes, and that is clearly in accordance with law. My lords, the only reason why we are before this honorable court is that, my lords, the legislative mandate and intention, as has been stated in, my lords, section 285 cap A of the Panchayat Raj Act, my lords. Lordship may see 285 cap A. May I, our primary contention is 285 cap A only states what the Honorable Supreme Court has stated, has held, my lord. That is, for local body elections or local body seats, my lord, the upper ceiling limit in vertical scale should not increase to more than 50%. And the section makes it very clear. The section states, my lord, and this is what the legislature has done in pursuance of the ruling of the Honorable Supreme Court in the decisions of Krishnamurthy, my lord, and I'll state that to your lordship, my lord, wherein, please see section 285 cap A, reservation of seats and offices in Gram Panchayats, Mandal Praja Parishad and Zilla Parishad. In pursuance of the judgments of the Supreme Court of India, I'll say Honorable Supreme Court of India, the upper ceiling of 50% vertical reservation, lordship may stress this point,
Yes.
50% vertical reservation in favor of SCs, STs, OBCs should not be breached in the context of local self-government, and accordingly notwithstanding anything contained in section 9, 17, 146, 147, 175, 176 and elsewhere in the Act, providing for reservation in favor of SCs, STs and backward classes, the seats and offices to be reserved for backward classes shall be so determined. Lordship will also keep note, may also note this, my lord, duly keeping in view the requirement of reservation in respect of SCs, STs therein, that the total number of seats offices reserved for SCs, STs, BCs shall not exceed 50% of the total number of seats, as the case may be, the offices in the respective local bodies in the manner prescribed. So, my lord, two things are being said here. That what section 285 cap A is doing, my lords, is essentially for giving a legislative imprimatur to the judgments of the Honorable Supreme Court, plus,
Correct.
which have held that in so far as vertical reservation is concerned, well, as opposed to horizontal, we are not on that because that's women and all that. We're not. Vertical reservation of seats are concerned, it shall not increase to more than 50%. And the section stresses upon the point that this is not what the legislature is doing, something new. It is only what the Honorable Supreme Court has done. And we are only giving a legislative mandate to what the Honorable Supreme Court has directed us to do. So one thing becomes clear, my lord, that in so far as vertical reservations are concerned, the ceiling limit of 50% shall not be breached under any circumstances.
Should not be.
Should not be, yes.
It is not shall, it should not be.
I'm sorry, my lord, I'm saying the shall because the Honorable Supreme Court has said shall not be breached under any circumstance.
That is Indra Sahni's.
Yes, I'm sorry, my lord.
Indra Sahni's judgment.
Indra Sahni's judgment, and later on Krishnamurti also, my lord, which we will be relying upon for local body election. In Indra Sahni, the law is clear. That was tested in Maratha reservation, wherein they have requested the court to send back 50% reservation to a larger bench to say that since 50% is not there in the constitution, and that is just the mandate of the court, it should be reviewed. The court specifically refused it. I'll show that to your lordship, my lord. It is now, my lord, it's now the law of the land that 50% shall not. The only exception which the Honorable Supreme Court has said, as your lordships are saying, in Indra Swani was that in far-flung or remote areas, like my lords, in our northeastern states, there the only exception was given that 50% can be breached. Later on in Rakesh Kumar, my lords, they said 50% can be breached insofar as STs are concerned.
Yes.
And this is what
Take the paragraph number immediately.
bench comprising of Honorable Justice Ramesh Ranganathan and another learned judge, my lords, have held,
1 minute, sir. You
have
said
held
first-
recently, my lords.
First is
Yeah.
that Indra Sahni, you said, next judgment is? You said
Krishnamurti, my lords. And the third judge, Krishnamurti, and my lords, the other judgment is Vikas Kishan Rao Gawali. So, my lords, as Vikas Kishan Rao Gawali, my lords, Krishnamurti is a 5-judge bench, a constitution bench. Lordships are aware, Indra Swani is 9 judges, and Vikas Kishan Rao Gawali is 3 judges of the Honorable Supreme Court. The last 2 judgments which I am citing are with specific reference to local body elections. Insofar as the Honorable Supreme Court decision in Indra Swani is there, my lord, that's the guiding light for all these decisions, for so far as to say 50%. That was stated way back in Balaji, my lords, 50%. That has been extrapolated later on and given the final seal of the Honorable Supreme Court in Indra Swani. So what I'm only trying to submit, my lords, is 285 cap A is an absolute bar, and what the legislature is now saying, is stating is, and that's still the law of the land, and it says that 50% should not be breached. I'm sorry, my lord. And the second thing which it states, which is also important, is that when you're doing this, you should also keep in mind 285 cap A is not just for backward classes. You should also keep in mind the interests of SCs and STs also. I'm only trying to submit to your lordships, my lord, the present GO which seeks to increase reservations now, my lord, presently have increased from 25% to 42% for BCs, my lord, while maintaining the reservations for SCs and STs as constant at 15 and 10. Therefore, if my lords were to do 42%,
just 1 minute. Whether increase in BCs has got to do anything with population?
my lords, I am glad my lords are asking that question, and that question has been answered by the Honorable Supreme Court in both Krishnamurti and Vikas Gawali. They say proportionate to the population as what the GO seeks to do, my lord. I'm glad my lords are referring to that, but that seems to be the intention of the GO. that the BC Commission has done exactly that. It has taken note of the proportion of BCs in the state and has said there is a need to increase it, keeping in view that proportion.
No,
That has been,
yes,
yes,
just 1 minute.
yes,
You're exposing the cause of OCs or
OCs. These two petitioners are not SCs, STs or BCs.
correct? Then, yes.
In the second one, he is an SC. In the petition filed, our client is an SC.
So you're exposing the cause of
The-
SCs. So you want reservations to be increased in respect of SCs? Is it your case?
No, that's not the case, but it cuts into our overall,
No, there is no cut in your reservation because your
no,
reservation.
not into reservation. Because we are not precluded from contesting the general category.
Manoj, in so far as,
The general category is cut down. If the SC, I can't now contest in SC category.
You can contest in your category.
No, I can contest in SC category, but not in BC category. BC category is curtailed.
So the increase is only 17%.
I'm sorry, Manoj?
Increase is only 17%.
Yes.
It is 17% and it breaches the 50% rule
Correct.
and it takes it all the way to 67%. And therefore, my lords, that 50% rule has been breached completely by 17%, not 1, not 2, but 17%.
See, just tell us what is the difference between a sarpanch or whatever it is, local body member, if he's elected. OC man, does he discharge any different duties? Or BC man, if he gets elected, will he discharge any different duties? What is the distinction? This, whether it is OC or BC, how does it matter to you? The nature of duties performed by a person who is elected by the masses,
Yes.
not by, unlike reservations in employment, reservations in education. That's altogether a different thing because everything depends on his merit and ability. Now here is a question, whether this is not political battle. This is only non-political elections, local bodies. Am I right? Maybe on paper it is non-political, but in reality something else is there. Now,
They all belong to,
no, parties are not supposed to contest.
yes. For MPTC, ZPTC, they do. For MPTC, ZPTC, my lords, we do parties, they do party symbol.
Okay. Ultimately,
Yes.
whether X stands, B stands, BC stands, SC stands, or OC stands, or ST stands, who is electing? It's the public who is electing.
Yes.
So unlike reservations in employment, reservations in education, it is, public has nothing to do because of your status, you are going and occupying that particular seat based upon in your individual capacity.
Yes.
But here, how does it matter whether it is a OC, BC or something? It is ultimately the public who are electing him. Suppose, got the point? So that seriousness of reservations like educational institutions and employment is something different than this. They stand on a slightly
Manoj,
different footing.
there's one thing, and this
Yes.
has been answered by the Honorable Constitutional Bench in Krishnamurthy.
No.
Manoj,
1 minute, sir,
yes.
just a minute.
Yes.
Judgments will be looked into at the time of final hearing,
Yes.
not at the time of admission, no, that's the
Yes,
point.
Only one paragraph to say 50% cannot be breached.
Correct.
And also to say the.
Yes,
section-
that is a
It is
repetition.
like, I'll try to answer. I quite see not what is passing in the.
No, we are not,
No, I quite see.
nothing is passing in our mind. Whatever is coming
No.
to us, we are testing the proposition.
Clarification sought from us
Right.
is
Yes.
like this. Not it's not just espousing the cause of one individual or one individual
Yes.
community here.
Yes.
What we are today saying is we owe our allegiance to the constitution.
Correct,
We are saying that we have to adhere to the mandate under the constitution.
correct,
The constitution prescribes a particular limit.
correct.
Now what, the apex, of course, then the
So
constitution will
this
not find it.
285A is referring to some judgments. What is the judgment? It is
No,
silent.
for the time being,
It is
I'm
only-
keeping aside the judgment.
We'll show that.
For the time being, but therefore, if when a mandate is breached, it's our duty to protect it and to stop this. That is why we are before this honorable court.
So this-
Secondly,
one
how
minute. Senior,
the
just 1
chances are affected is,
Just 1 minute, senior. 285 is so vague, so vague.
no, 285 again owes its existence to another judgment of this honor, of the Supreme
Maybe-
Court.
Just listen, look at the language used.
That's true.
It is so vague. It is so vague. In persons of the judgments of Supreme Court, which
That's-
judgment, nobody knows. So it is so,
It's Krishnamurthy judgment.
Well,
That's why we are here.
No, that is right. You're trying to fill up the gaps in a section.
Yes, yes,
Section should be understood in a plain reading, the way it is.
yes.
The interpretation has to be done. Interpretation requires final hearing, not at the admission stage.
No,
That's
but
the point.
please notice one thing, my lord. The legislative.
One more thing.
Yes.
This court is in the habit of indicating its mind. Don't get carried away that we have made up this mind or that mind.
no.
In order to test your argument, we are trying to put
I've
such
seen my
questions.
lords for so many years, your lordship. no
Thank you
need
very
to
much.
Say that.
Correct.
I've seen, we have
Right.
both seen your lordship.
Yes, yes.
There's no need to
Because-
say
And
that.
we are also here to argue the case. not
Correct.
just- Because they
Why
say,
we are asking certain proposition is so that you can understand
Yes,
and
yes.
argue in a better way. That's only our idea, not that we have made up our mind and.
no, the arguments of an advocate only begins when
Yes,
the
yes.
bench doesn't agree with the contentions.
We are-
Therefore,
Yes.
we agree with it. It's
Yes.
all
There's no question.
mutual exchange of ideas.
There are no questions from the bench. We would be left wondering whether we are, forget about being interesting, whether at least we are intelligible or not.
No, not like that.
Well, I'm obliged.
Please.
But what is clear from section 285 cap A?
Yes.
Just one thing is clear, my lords, and that is upon a plain primary interpretation, one thing is clear. I'm obliged to my lords, my lords.
Correct.
What are the judgments of the Supreme Court? We'll just show, but that's besides. What is clear? and
Section
what
should be
clear.
definite,
Yes,
clarity.
Clarity.
Then only
yes,
you can interpret
Yes,
that.
my lord.
Suppose if the section itself is so vague
Vague.
and it is so.
Yes, yes.
So interpretation of that particular section.
yes, yes.
According to you, this particular three judgments of Indrasane, Krishnamurthy and Vikas,
Yes, yes.
Kishan, Gawali or
Gawali,
something.
yes, yes.
According to some other judgments of Supreme Court. So it requires lot of
It's a
interpretation.
law of the land, it's
Law of
anyway
the
binding.
land, yes.
But one thing is clear, my lord. One thing is clear, my lords. Please notice this one sentence, and that's where our entire case is. The upper ceiling limit of 50% vertical reservation in favor of SCs, STs, BCs should not be breached.
Yes.
Now, one thing is clear, my lord. Insofar as vertical reservations are concerned, with your lordship's permission, we'll take your lordship's judgment. That's secondary. But what is the legislature has understood from those judgments and extrapolated it in the voice of the people in 285 cap A is that the upper ceiling limit of 50% vertical reservation shall not be breached. That's the law of the land. Now, what they are doing presently, and this is our primary contention before your lordship, is the executive is going against the legislative intent and trying to breach it not by 1 or 2%, but by 17% and increasing it to 67%. So presently, my lord, that's our entire case. And that is the case at the time of admission. That, my lord, 42% BCs presently from
In this EWS is also included?
I'm sorry, no,
In this EWS is not there?
that's horizontal. They come under horizontal. Women, EWC and all that's horizontal. They intersect with vertical, my lord, but vertical is what we are concerned with. That the courts have also made it clear. If that were, yes, my lord. So what our primary contention therefore is that 42%, 15 and 10% bringing it to 67%. If your lordship were now to go to the impugned geo, the geo, my lords, I'm just taking a leaf of your lordship's question.
One
Yes,
minute, might just answer this.
yes.
That
Proportionate.
EWS is not applicable for SC, STs and BCs. It is only applicable for OCs, right? That is horizontal.
It's horizontal. Like women, my lord.
Right.
Women's reservation is horizontal.
So existing 50 is now taken to 60 with. There is no EWS.
But generally, my lords are asking
No,
about
there's
EWS as a
service-
principle.
Yeah,
It's
That is the difference.
No,
horizontal.
that will not arise here.
Courses and employment.
There's only an employment,
Employment
professional
and-
courses.
But insofar as this is concerned, therefore, my lord, 67%. Now, how the geo seeks, I'll come to the relevant parts of the geo says that we have constituted a specialized body called the BC Commission. It has done an empirical study. The empirical study has shown to us, that is the executive. Now, this is done without referring to 285 cap A,
Correct.
under which it functions.
Yes.
Because the executive is also bound by the rule of law
Correct.
as is spoken by the legislature.
Correct.
Now, what they seek to say, there's a commission, it has done an empirical study. That empirical study has shown that BCs are lagging behind, backward classes are lagging behind proportionately. And there is a need on us to increase it, to increase the reservation so as to bring them on par. On that, my lord, there are two problems. One is the Honorable Supreme Court has held, my lord, proportionate reservation in so far as backward classes are concerned is a complete no. Proportionate reservation only for STs are allowed. Proportionate reservation for BCs are not allowed. The court goes on to say, you can increase it in any manner you want, BCs, SCs and STs, but you shall not breach the ceiling limit of 50% under any circumstance. The only exception being that of STs. Now, what the GO seeks to do is something directly against what the Honorable Supreme Court's holding is and what this court has recently held, my lords, just recently in 2018, wherein, my lords, BC's reservation was sought to be increased to 34%. A division bench has struck it down by applying Krishnamurti. My lords, but please see the operative portion of the GO. May I read, my lords? Please see here, my lord. Yes, my lord. And may I read from 7th para, my lords?
Which page?
Page 29 of the first matter. I'm sorry, my lord. This is, yes, 3017 of 25.
Yes,
Yes, page number 29.
There is GO.
Yes, the GO, impugned GO.
Yes.
I was just like placing before your lordship what the GO did, my lords, that the commission is appointed, found proportionately speaking, BCs are lagging behind, and therefore to bring them on par, we will increase it to 42% without any reference to 285 cap A, but very cleverly only referring to a bill passed by both the houses, by which they sought to amend 285 cap A. Now, I may say, my lord, 285 cap A also stands insofar as the legislature is
No, that proposed amendment is
pending before the governor for his assent.
Since when?
For 1 month, madam. Since 1 month.
What
And
is
he has sent it to the president.
some Supreme Court judgment?
Yes, 3
recently
months.
Something.
3 months as the.
So that has become final or that is? Huh? Some, I think president has, Her Excellency has referred some 5 questions to
That is reserved.
Supreme Court.
That is reserved. Now, what the
Again,
governor,
president has referred and the matter is heard.
the
Now
governor,
it is caught up in 2 situations, I think.
my lord. Now, therefore, my lords, if the governor has not given his assent, 285 cap A remains the law of the land, and their reference to a bill amending 285 cap A is a mischievous exercise, because what relevance does a bill have unless it receives the governor's assent and that amendment becomes law? And please, I'll show to your lord.